chapter 24, we deal with real property as compared to personal property, which we covered in the last chapter. And then we'll get into a little bit into environmental law. So the nature of real property is basically it's your land, your house that's attached to that land, any fixtures that are on the land. So like your driveway, if you had a shed or an outbuilding that was permanently attached, an in-ground pool. So basically anything that is attached into the ground and cannot be removed without damaging the property. It includes actually your airspace above your property line. It includes any mineral rights that you have in the ground, any natural products that are growing on that real property. So if you have a tree or you have, shrubs and flowers and plants and stuff like that, all those things are included in your real property. What types of ownership interest we can have. Whoops, sorry, I went too far. Those are considered possessory interests when it's that you're living there. So you own it, you've got the right to possess that property. Fee simple absolute is a term that we had with our personal property as well. It's when we own the property outright. So we've got the right to do anything that's legally allowed with that property. So we could sell it, we could give it away, we could let it just sit and waste, assuming we're not violating any zoning laws or any county laws. But in general, we can do what we want with that property. A life estate says, okay, a holder has the rights of possession during their lifetime. So a life estate is good, I think, for like, say, a second marriage. So say you and your first wife had this house and you had your children in it, or your husband, and then you guys get divorced. And then you remarry. Well, then if you were to pass away before your second spouse, you don't necessarily want to kick them out of the home, but yet you maybe don't want them to get the house. Maybe you really want the house to go back to your children when that spouse dies. So you could set it up as a life estate. So while that second spouse is alive, they have the right to use that property. But when they pass away, it's not going to go to their heirs. It's going to go back to your heirs. It's going to go to your children. So sometimes that's a helpful thing to be able to kind of make both people happy. So the spouse can stay, but then the children are going to end up inheriting that property. So then they have the same rights as any homeowner does, but they have a duty as well, because they know that they are not really the true rightful owners of that property. They cannot waste it. They must keep up on the taxes and the repairs and the insurance and everything that's required of them. If it's a non-possessory interest, it's more like a rental property or the right to use a property. So those people have no rights. I mean, obviously you can't sell it, you can't give it away, you can't get a loan on it. So the easement is a right to use another's property. And a good example of an easement that we have in our current properties is like a shared driveway. So say you have two houses on each has their own separate lot of land, but they share a driveway going up. So you both have the right to use it, but you really can't sell it, give it away, kind of make any major changes without both parties agreeing. An easement for property is the easement for profit is the right to use a piece of property for some sort of profit. So like an example that I have is a natural gas lease. So I worked at an oil and gas company. We didn't own any of the land that our gas wells were on. We had an easement for profit. So somebody owned those lands and then we gave them a royalty. So we had the right to come onto their property. We would even build a lease road. We would fence in that well. But that would be an example of us being allowed to be on their property and drill it, but then not actually have any other rights to it. A license is when it is like our stores and restaurants where they are inviting the public to come on their property so that they can do business. How ownership for real property can be transferred is through a sales contract, and we'll talk a little bit more about those, or those are kind of more your just general that you expect to have a specific type of a like that warranty of habitability, that everything's going to be fine and in working order. If the seller knows of any hidden defects, they have to disclose it. And then nowadays we have a lot of inspections that we go through with those real estate sales contracts. We'll talk about the different types of deeds that can be where we can transfer ownership to other people through just transferring that deed. We could inherit that property. It could be through adverse possession and eminent domain, which are kind of unique scenarios that we will have a separate slide for. So our three different types of deeds that we can have when we're transferring legal title to real property. A warranty deed is what would be part of like a real estate transaction. So we actually normally we pay a title company to provide us that warranty deed. So it says, okay, we've searched it, we've made sure that this deed is free from any claims, and that it's a good title. So normally as a buyer of real estate, we pay for that service just to make sure our interests are protected. A special warranty is saying that seller had good title while they held the property, but they're not going to warrant any defects prior to them. So like if they had it for 20 years, they're saying, hey, during my 20 years, it's free from any claims. There's no, everything's been paid up, taxes and all that stuff. But prior to that, I don't know. A quick claim deed is you pass whatever interest you have to the other owner. So a lot of times in a divorce, there'll be a quick claim deed. So the one spouse signs off all their interest to the other spouse. Maybe you have a property with your parent, and that parent, it does a quick claim deed, signs off their interest and provides you with it. So the quick claim deed would have to be someone that you know and you trust, and you understand that you're just getting their interest in it. Obviously, if we're buying from an outsider, we would want the warranty deed. Adverse possession is, again, a very unique scenario. It makes me think like probably back in the old Wild West times. But you can acquire title to a property by occupying it over a statutory period of time. And that statutory period of time is set up by the state. So the key to it, though, is it has to be open, exclusive, and continuous, and then without the owner's permission. So, say you find some land out in southern Ohio that nobody's using, you clear an area, you bring in a manufactured home and you set it down, or you build a home, and you get mail delivered there, you entertain there, people come over for the holidays, but you've never bought it, you don't know who owns it, but you've just taken it over. So say you did that for 5 years, at the end of those 5 years, you would be awarded that property. So you would have ownership over the rightful owner. So it's kind of trying to say that, like, if you own a bunch of land, you need to know what's going on on that land. You can't just own it and be in a whole nother state and never even come check it out. If you do, somebody could take it over by adverse possession. Eminent domain is the government's way of taking property. So they can take private land as long as they're using it for public use and they are providing just compensation. So they're going to give you fair market value for what that price is. So maybe they're going to create a big public park or a new walking path, or they're going to expand the highway or or expand the route that you live on. So those are all ways that the government will take over by eminent domain. But again, they have to pay you fair value, at least for your property. Then we get into leasing it. So leasing it's another way to own, to live in a house or a real estate property. We don't own it, but we lease it from the person who does own it. So there's different types of tenancy. The most common is going to be our fixed term tenancy, where it's an express contract for a specified period of time. So say it's an apartment, it's probably for a year. If it's a commercial space, it might be for 3 to 5 years. Sometimes after you go through that fixed term tenancy, that year of being leased, you could go into a month-to-month tenancy. So that's called a periodic tenancy. I think a lot of the bigger companies, real estate companies now, make you just go from one fixed term to another fixed term. But some of your smaller landlords, you may kick over into a month-to-month lease. So then you just have to give them 30 days notice if you're going to move out. A tenancy at will is when they can terminate without any cause or notice. So like you could say you don't have to give them the 30 days. You could just move out and you're done and you're over. A tenancy at sufferance is when the person is no longer paying rent. So they're still in the apartment or the house and they haven't paid you rent. That would be a tenancy at sufferance. And you'd have to try to get them evicted to get them out. The lease agreement normally covers all of the rights and duties. So it says the tenant can use that property exclusively until that lease expires. There might be things that they can and cannot do on the premises, like maybe you're not allowed to have a boat or an RV. Maybe you're not allowed to run a business out of it. You're not allowed to sublet it. Things like that. The rent will discuss what needs to be paid. What's the deposit? Is there a late fee? The landlord can sell that property at any point because again they go back, you go back to their ownership. They have the right to sell it or gift it or do whatever while they own it. They could then honor your lease, the new owners, or maybe not. Then the next two items, the assignment and the sublease, are talking about you as the tenant. So the tenant cannot assign their rights to a lease to another person without the landlord's consent. And many times the lease agreement will say that they cannot assign it, period. And if the lease agreement says that that person cannot assign the rent, then they cannot do it. A sublease is when maybe you started into the lease and you can't finish it, so you're going to sublease it for a part of the time, or maybe you're only going to sublease a piece of it. Maybe it's a whole house and there's an office space up front that you could sublease out to a local accountant or an insurance person or something like that. So again, if the lease agreement allows for that, you could do it. If the lease agreement does not, then the tenant cannot do that. Then we get into environmental law. So there's common law that governs some of these things. We've got a nuisance doctrine where what the business does cannot interfere with other people's rights to enjoy their properties. So, if there's a business right in the middle of a community, there's things that they can't do if it's like noise late at night or, bright lights or things like that. Now, the only time sometimes it does give the example of the courts may allow it if shutting that business down or stopping how they're doing their operations would actually hurt the greater community. So then in that case, they may allow for that. So I always feel like it's a bummer for your real estate values if a large company is close to your house, because most people don't want to be that close to a large business. Then we have some federal regulations, so the EPA, which is the Environmental Protection Agency, and then the EIS, which is the Environmental Impact Statement. So those are going to discuss how we can improve our air and water quality, and what chemical toxins can be used and what can't be used, and how they need to be disposed of if they are used. We have the Clean Air Act, which is trying to deal with our air pollution and cut dangerous emissions out of our air. And so companies that violate these laws can be charged up to $5,000 a day. We are also have a Clean Water Act to try to stop water pollution, making our water safe for swimming and for wildlife, and then just even our drinking waters and our white water or our clean water, not the wastewater. And then wetlands are many times protected and need to be kept safe as a natural wildlife habitat, because we all know that if we start impacting some of our natural wildlife habitats, it has greater implications on the world than we realize. So there's a lot of different ways to protect that. And obviously our drinking water is very important. And and then, we've had some oil pollution stories maybe in the past 10, 20 years. And if there is any type of oil pollution like out in our ocean waters, everybody who touched that oil is liable. So the person who created the oil, the shipper who is shipping it, and the person who's running, who's actually, the operator of that vessel, all of them could be liable if there was any type of pollution. Hazardous waste disposal, this is another one where it kind of pushes liability on a lot of different people. So this super fund says that, okay, if there's hazardous waste that is not disposed of properly, then everybody also who touched that hazardous waste could be liable for the cleanup. So the people who produced it in the first place, the people who transported it, and then the people who were supposed to dispose of it properly. So that all three of those people could be liable if there's a cleanup necessary. Okay, so that is our real property.